Hi, Melinda. How are you? All right. Good morning. Oh, the interesting experiment is how many will not be here now that you all have access to the recordings. That's about half of you. All right. All right. So let's just talk about a few administrative matters. Can you hear me in the back? We're good? Okay. All right. So I'll have office hours again next week. Had a lively discussion. You know, the fun thing about coming to office hours is that you get to throw around hypotheticals that are inspiring to think about. For me, they inspire me. They sort of could be great things to ask on an exam, but I don't know. But it's also kind of fun. Like, we get to think about all sorts of cool cases, and I encourage you to come just for the value of, you know, thinking about this stuff. So next Wednesday, but don't worry, I'm not gonna, you know, give the people who went to office hours that much of an advantage. It's not gonna be that unfair, but it is fun to kind of think together about hypotheticals. We threw out a few yesterday, like what happens if one company trades in the stock of another company? It's kind of a fun hypothetical, right? Because, you know, if the CEO of Apple were to short Google right before, you know, a surprise iPhone announcement, not that that would probably do much today, but I don't know, there was a time maybe when if Steve Jobs had shorted, I don't know, Microsoft right before announcing the iPhone, or I don't know. You know, you probably have a misappropriation theory problem. I mean, you know, it would be illegal probably under the misappropriation theory because the CEO presumably receives that kind of information from Apple pursuant to a duty of confidentiality. So this is sort of an O'Hagan case, a pretty straightforward one. But it's a lot less straightforward if the corporation authorizes the trading or actually just conducts the trading. Kind of the same thing. It's less straightforward because there's no misappropriation. In fact, we'd be talking about information generated by the firm. And there's certainly no classical theory, and there's no tipping, and there's no breach of any fiduciary duty, actually. And so short away, right? And that's kind of interesting because if you are thinking about, so, you know, is that information transmission? And you're saying, well, is it a good idea, sort of from the standpoint of Google's investors? You know, you might think sort of like our Elon shareholders that, you know, if company A is going to make an announcement that's going to negatively affect the value of company B's shares, I mean, have at it, right? So, you know, this is an interesting problem because there is this growing sense that a lot of companies, I should say this isn't so recent, I guess 5 or 6 years ago there was a lot of conversation around how corporate America is sitting on so much cash and kind of acts more like hedge funds, so to speak. And we were joking about this at office hours that, like, you know, Columbia is like a hedge fund. So is NYU. Like, Harvard is a really good hedge fund. Yale. So these sort of non-investors are actually speculating all the time on the market. In fact, you might go further and say that, you know, if you are you're a firm and you think about your cash flow risk is positively correlated with your industry. So when your industry does better, you do better. And when your industry does worse, you do worse. But you want to insure against changes in the value of your competitors. That is, you want to sort of isolate the portion of your cash flows that are driven by your own business acumen and skill and so forth. That is, you don't want the variability of your cash flows. You don't want to be getting a lot of money just when other companies are doing well and not a lot of money when other companies are doing poorly. If you're concerned about that, you might very well want to be shorting your competitors, right? Because if you were to be, so if you think about it, like if the company itself always has kind of long exposure to its own cash flows by definition. So if it shorts its competitors, what it's basically doing is just hedging out industry-specific risk, common risk to other firms in the industry, which might be useful for some reasons. And what I'm suggesting is that doing that kind of hedging on the basis of material non-public information might be just fine. All right, so that's a fun setting to think about. Are there questions on insider trading? We're going to kind of wrap up, well, right now, actually, insider trading. Questions? Anything we talked about the last couple days that you just want to go back over one more time? No? All right, so roadmap from here. So in the next couple weeks, we're going to complete our class by talking about securities fraud in the non-insider trading sense, right? So the vast majority of securities fraud litigation that fuels a very active and prosperous plaintiff's bar is litigation around the purchase or sales of securities that happens on the basis of incorrect information, either because there was a material misrepresentation or because there was an omission. And the claim that's animating the lawsuits that we're going to be talking about in the next couple weeks is that as an investor, I was harmed by securities fraud. So unlike in the insider trading sense, we're not going to be thinking about sort of, the public interest in, well, how would we call this? And not letting one actor sort of exploit their inside information. Instead, we're going to be thinking more generally about the rights of these investors. Now, there is a connection, right, an important connection between the two, which we kind of illustrated yesterday, right? So if you were an Elon shareholder over that window, one way to think about this particular group that we're talking about is to say, well, if you were one of those shareholders who bought at $35, I mean, can you bring a lawsuit? Like, do you have a basis for a claim? Should we allow you to have a basis for a claim? So there's going to be a positive legal question around the scope of civil liability and a normative question around who should be able to bring private securities fraud claims. But before we get there, let's just kind of recap and reiterate that at first glance anyway, it's not immediately clear why we need private civil liability. Up until now, we've talked about securities law as a set of substantive rules that have largely been promulgated by and enforced by the SEC. So in the case of, let's go back to the 33 Act, right? In the case of Section 5, we looked at cases where the SEC stepped in and tried to get an injunction against the sale of unregistered securities or securities in violation of Section 5. We saw that in the case of a registration statement, there has to be SEC review of that registration statement before it can be declared effective. So if you think about institutionally, the way that securities law empowers particular actors to enforce these substantive rules, it thus far seems to be primarily in the hands of the government, right? So this is true under the 33 Act pretty much throughout, until we got to Section 11, where we saw a specific statutory remedy for those named individuals under Section 11 who had purchased in the IPO based on a violation of Section 11 or based on a material misrepresentation or omission. That was a statutorily granted, cause of action to these individuals under very defined standards subject to certain defenses we discussed. And we discussed a couple other, for example, the right of rescission under Section 12, where Congress is stepping in and saying, we're going to give you, as a matter of statute, we're going to give you a right to bring an action as a purchaser of these securities. Now, that makes sense under the 33 Act. When we get to the 34 Act, it becomes a little bit trickier, right? Because secondary market trading doesn't seem to have the same clearly delineated moment where there's a sale of securities by an issuer and you have purchasers and you're trying to give a remedy for those purchasers when the sale occurred in violation of the 33 Act. In the case of the 34 Act, you basically just have secondary market trading between buyers and sellers that's happening all the time. So if we continued the framework, we could say, well, the 34 Act has, first and foremost, empowered the SEC with the authority to promulgate rules and to bring enforcement actions. And in fact, all of insider trading law basically consists of SEC and DOJ, under the criminal version of these statutes, going around and policing the securities markets. So why do we need to go any further than that under the 34 Act? As a matter of positive law, it's not clear. And just to, I guess we could, I won't take the time, we could look, you can look back at Section 10b, but unlike Section 11, there's no statutory text saying that if you bought or sold on the basis of a material misrepresentation or omission, you may sue someone. Now, you can see right away why that would be actually quite difficult to write, because who are you going to sue? You're going to sue your counterparty who sold you the security on the secondary market? That's a little tricky, right? Because often your counterparty had no idea that there was some material non-public information that you bought the security without knowing, or had you known, you would not have bought. Sometimes, in the case of insider trading, maybe you can say, Martoma's counterparties who were buying from Martoma at $35 or $34, whatever it was, they are, this sort of victim class that we can identify. But actually, Martoma's counterparties were dealers. They weren't individuals who sort of were taking actual long positions. Formally speaking, when Martoma goes to sell, he sells to a market maker, to a dealer, and that dealer just offers a price at which they'll buy from Martoma. And as we discussed earlier, that price, is supposed to adjust for the possibility that they're facing a Martoma. So some of the time, we said in our $9 and $11 conversation, some of the time, you're going to be, if you're a dealer, you're going to be buying shares from someone who is informed, and some of the time, you're buying shares from someone who's not informed, and so you're going to set a price that basically lets you break even, that reflects the weighted average of those possibilities. And so I guess we could give the market makers a basis for a civil action here. We could let, the high-frequency traders who bought from Martoma, I guess we could let those counterparties sue Mr. Martoma. It would seem, a little inefficient, right? Because Martoma is already probably just being discouraged. I mean, what do you think? Do you think that can anyone think of a sort of coherent, and this is really, you see this in the cases, this is not easy, a coherent sort of story whereby secondary market trading, I mean, can you imagine, can anyone think of a parallel to Section 11 where if we inserted, they may sue in 10b-5, there would be a clear sort of story as to who may sue whom. Does anyone sort of have an idea? Like, does this sort of seem very easy to anyone in the room? Like, why are we talking about this? I mean, it's not easy. Right? It's not easy. Yeah. I mean, it's not easy, right? Because if you think about the counterparties to Martoma's trades, I mean, effectively what's happening is, Martoma is selling to a sophisticated buyer who knows they could be facing an insider, and the real problem, the real sort of victims of Martoma's trading are those folks who bought at 35 from another dealer. Probably, it's not the same dealer and it's not the same people. It's not actually one person connecting Martoma to their buyers. So, I mean, it's kind of hard to articulate a story whereby any particular buyer was actually being defrauded by Martoma in the actual legal transfer of title to the security. And by the way, this is kind of a nice opportunity to talk about a question that I find interesting that may be on the exam, so just think about this. As a sort of last policy question, maybe, which is the sale of is a security, a share of stock, is that a contract? Is an equity security a contract? So a debt security is definitely a contract, right? Because it is a promise to pay a particular amount on a particular date that was bargained for in exchange for consideration, and therefore a contract, definitely. A bond is definitely a contract. Okay. Is a share of stock a contract? So if you Google that, contractarian theory of the firm, you read these papers which sort of talk about, shares of stock as if they are contracts. But since this is Columbia and you all want to be lawyers and you like the law, lawyers in the room, is a share of stock a contract? Not can there be contracts to buy and sell a share of stock, but is a security a contract? Of course there can be contracts to buy and sell anything, but is the actual share of stock a security? So one view is to say that when the IPO happens, the purchase of the shares in the IPO is actually a purchase of a bundle of rights, right, that you get as a shareholder, and thus the IPO is actually the formation of a contract between the firm and each buyer of the firm's stock. Specifically, in exchange for the consideration paid at the IPO, the shareholder receives certain rights. The rights include the right to an annual meeting, to choose the directors, and so forth and so on. Right to actually, most importantly, the residual claims on the firm's cash flow, so the dividends. And thus, in that view, a sale of stock on the secondary market should be construed as an assignment of those contractual rights. That's interesting. Does anyone disagree with that characterization? Yes, Davia. Do you disagree with that?
Not in the slightest, but I just...
Oh, the last sentence? So what was the last sentence? I forgot. So It's an assignment, right? So the purchase is an assignment. Does anyone disagree, Magdalena? Oh, well, if the IPO, I'm not going to say it in new words because I just can't remember the words I used. If the IPO, but it's being recorded, don't worry. So if the IPO, like at least a lot of you aren't here, so for those listening, you know, well done, rational students. Okay, so so if it's an assignment, so if the IPO is a contract, right? So if effectively what's happening at the IPO is that the firm is selling a bundle of rights that come with equity shares in exchange for the IPO consideration, then a secondary market sale by the IPO buyer to the next buyer. So I buy from you, Davia, in the IPO, and I sell to Magdalena. Magdalena is, under this view, I am actually assigning my rights against you to Magdalena in exchange for the consideration she pays me. That's the contractual interpretation. Does anyone find that not convincing? I got like these skeptical looks on the front row. Hang on, Martin. Yes, Magdalena. Property, yeah. No, there's a property, is a competing property interpretation I think is maybe more convincing. What do you think, Mariah? Yeah. Yeah. So there's a sort of pro-property view. Does anyone agree or disagree with one or the other? Martin, you have your hand up? Yes.
Yeah, I think I agree with the property just because you can define anything as a bundle of, like any piece of property is a bundle of rights to some extent. And there's also thinking about it as a contract, then aren't there, like, how can the shareholder breach that contract?
Right, so that's the most convincing for me. So typically in a contract, although there are contracts where, you know, I've paid for a service and I have an entitlement. I can't buy me my, you know, it's executory from the standpoint of my counterparty, but my performance is fulfilled. So, but I do think that argument's persuasive. Martin's point is persuasive because it's not easy to see how in the secondary market the purchase by, you know, when Magdalena buys from me, it's not easy. It's really hard to construe that sale as an assumption of some kind of contractual entitlement. It really is a stretch. I don't think it's what we're doing on secondary markets. Also, like, we're not thinking that way. Also, the bundle of rights you get as a stockholder is defined by Delaware law, by and large. If it's let's say a state corporate law, if it's a Delaware company, Delaware law. You could view the charter as sort of a contract, but only in the very theoretical sense, right? Because at the end of the day, in the charter, I mean, the board of directors can unilaterally modify the charter, so it doesn't even comport with the doctrine of modification we have. So I think the property analogy is more convincing. Why are we going down this rabbit hole? Well, you have to think about it like this, right? If you embrace this contractual view, then in the primary market, you can say, well, you know, there is an implied duty of good faith or so we can reason common law-like, right, around the bargain and say if you bought or sold on the basis of a misrepresentation or omission, then there's a clear chain of liability. If you embrace the contractarian view in the secondary market, then it would be not so hard, right, to think of securities fraud as a codification of standard remedies that you would have for misrepresentation or deceit at the common law in the contracting sense. And thus, there might be a basis for sort of quickly accepting, right, a private right of action. Because at the end of the day, you bought something. You bought it under false pretenses, or another way to say this is you bargain for something, and what you bargained for, was wrong. Right? There was misinformation, right? You were misled in your bargain. Now, when we look at the Carden case, is another reason why I think the contractarian view sort of falls apart. One second. We look at the Carden case, we don't see a reference to contract law at all. Abir, yes.
What's the difference between the property approach and the contractarian approach? Because you can't transfer title without a valid contract, right? So unless unless the thing is unpossessed. So could you just explain what the difference is?
Well, so the problem with so when you think about the IPO, okay, it's let's put it like this. You could always say that a contract, that the rights you have under a contract are like property in a way, right? In fact, they can be bought and sold like property. So I have a contract right. That's an asset that would show up if it had a market value. It could be actually put on my balance sheet. And so in a way, any contract right is a kind of property. Okay, so the real question is, does the contractarian paradigm describe, well, what's happening when folks buy and sell securities on the secondary market? Notice, in the case of debt securities, the answer is clear. Yes. Okay? So I'll make sure this point, really drive this point home so everyone understands this. If you buy a bond, okay, so Davia issues a bond where she promises to pay the bondholder $10 a month. I buy that bond. I give her some money, and she owes me, by contract, $10 a month. It's a contractual obligation that she has towards me. You could view that right as a property right, very generally, but start with debt securities. It's very clear that there's a contract between us that I can sell to Magdalena. In exchange for consideration, Magdalena is now the holder of that right. If Davia fails to make that payment, Magdalena can sue Davia for breach of contract. That's a contractarian paradigm. Now, that's a security. And the trade was effectuated on the secondary market in a manner that, from all observational, all intents and purposes, when we look observationally, is identical to the sale of an equity security. Suppose Davia just replaced that debt security with equity, sold it to me, I sell it to Magdalena. It looks the same. It trades, it has a market price, no physical documents change hands, but yet something seems different. And it's only because we've switched from debt to equity. Sam.
Yeah, I was wondering if you think the argument is any stronger for companies that have dual class stock or for preferred stock. Because, I mean, I think if we're just talking like a company with one class, common stock, then maybe that seems like everyone just owns this company, has control over it. That seems more like property. But if you're talking preferred stock or non-voting shares in like a two-class company, that seems more like a contract for the residual claims.
Yeah, Sam makes a great point, which is let's think about preferred or convertible, right? So there's actually a spectrum of securities that lie in between the debt and equity extremes, right? Between stock and bonds. You have preferred stock, which entitles you to priority in payments in the event of a liquidation, and in other cases when there's distribution to the shareholders. You know this, the preferred stockholders are preferred. We have all kinds of convertible bonds that can convert into equity. Are they contracts? So it is somewhat of an academic question, but it's not, right? Because when you look at Carden, what the court is trying to do in Carden is find a basis sort of analytically, theoretically, and intuitively, I don't know, for why there might be a private right of action for misrepresentations or omissions in the secondary market. Just to really drive this point home so everyone understands, imagine we all agree that there's a debt contract and there's a misrepresentation or omission in connection to the sale of a bond. Okay, under this contractarian construction of that transaction, you can say, look, you know, if you know, and not to pick on Davia, but if she were to say, look, Davia sells me this bond, and she's misrepresenting something about her company, and my sale of that bond to Magdalena is an assignment of my rights, and one of those rights includes, you know, damages for misrepresentations, or a right of rescission, or whatever contractual right you want to fill in, either in the actual text of the bond or read in as a default rule by law, Magdalena has an automatic private right of action. In the contractarian construction, she has a contract right. The contract right is, right? That is, Davia would be in breach of contract. It's putting this differently, so everyone sees this in this story, right? That is, some sort of misrepresentation or omission would violate a warranty, an implied or express warranty that Davia is making, and thereby give Magdalena, and we wouldn't disagree at all about Magdalena's right in that setting. In fact, this happens all the time. Christian.
Just a thought about the property articulation. It seems like you would be able to justify a private right of action there, too, because if you viewed the equity security as some sort of shared ownership, in joint tenancies and co-ownership, you can sue for waste or things that another owner does to diminish the value of your property. So it'd be a bit different, but it seems like you could still make that argument.
Yes.
Right?
I can barely hear you, but I think I heard you, which is that if you have, if we sort of embrace this property view, we could say it's like a waste claim, right? That was, yeah. So, but that requires joint ownership. I mean, I guess I would think in the property construction, what we're saying is I own the share of stock. I'm the sole owner of it. So maybe like nuisance law, or like we could analogize to, you know, dilution in the trademark setting for those of you who like IP, right? Or just trespass, or trespass to chattels. I don't know. Like there's got to be some doctrine we can sort of grab a hold of and say that's the okay. Well, what did the court do in Carden? Okay, so let's like back to earth. It's Columbia after all, so let's. You guys, you have we have fun. So what was the basis, the common law basis for Judge Kirkpatrick's holding in Carden that there is a private right of action for violations of 10b, 10b-5? Thursday. Yes, Alistair, what's up?
Yeah, he bases it on tort law,
Right.
on the restatement of torts.
Yeah. So, what exactly about tort law?
That the violation of a legislative enactment can basically give rise to a private right of action if the intent is to protect the interest of like a specific group of individual, and that interest is invaded.
Yeah, so the restatement. You guys remember the restatement? It's back. All right, so the restatement, you know, this is kind of, this part of the law is kind of fun because, you know, it's like Paul's graph is going to come back. It's like it's all going to come back. So here we go. So the restatement, the disregard, this is, you know, in this 293 of the reader, right? The disregard of the command of a statute is a wrongful act and a tort. So neither property nor contract, right, in Carden. It's not a, Christian's elaborate, which I think is cool, sort of story around, you know, I don't know, you're a property owner, you own a claim to the residual cash flows, and the firm or someone engaged in a material misrepresentation or omission that destroyed the value of what you owned, and therefore you can bring a claim for waste or trespass. No, that was not it. Definitely not contract. It's just a statutory violation which gives rise to tort liability. All right. So, any questions on this? Is this clear? Yeah, Abir?
I still don't understand the significance of the property contract a bit, because almost every contract can be conceptualized as a property. So,
Well, contract rights can be thought of as property, but contract law provides for a series of remedies that are unique to contracts. Okay, so in this, go back to this story, okay? I sell debt to Magdalena. Magdalena has a bundle of rights that are defined by the debt instrument against the issuer of the debt. In an assignment, okay, to make sure this is clear, in an assignment, the rights that were bargained for initially by the assigning party are transferred to the assignee in exchange for consideration. And those rights, the starting point for figuring out what those rights is literally what's in the document. Because that was a negotiated transaction between us, and that entitlement passes to the buyer. The problem here, so just to make this point clear, if we were to construe equity security as a contract, what we'd be saying is there's a set of representations and warranties, implied or expressed, in the share certificate that create, or the corporate charter, or you name it, that creates a contractual right to every assignee, that when I sell, the assignee receives that. The violation of those representations and warranties, one of which may be a right to hold the equity share without there being material non-public information in the market, for example. Okay? And so the violation of that representation, the representation that the price of the stock is fair and accurate and that there's no misstatement or omission that could change the value of the firm, think of it that way, that representation would clearly give the buyer, in the case of an assignment, a cause of action against the counterparty to the contract, the firm in this IPO story. Okay? Or if we could even go one step further and say, suppose we viewed this as a set of contracts in the market where the Martomas of the world are basically warranting to their counterparties that the transaction is without fraud or without misrepresentation, then every agent in the chain, the contracting chain, could be sued for violation of that representation and warranty. Under the property theory, none of that is true. None of that holds. So that story makes a lot more sense with debt, because you can say in the debt contract, there's a set of representations and warranties that every holder of the debt in the chain of title is entitled to pursue, because that is a contract, and those contractual rights follow with the assignment. That is not the case. If we think about it as property, we're going to have to find some other basis to read in a violation of something affecting the value of that asset, and we're going to have to decide who gets to be sued and who sues. And those decisions are going to have nothing to do with a bargain. They're going to have nothing to do with a sale. They're going to have nothing to do with a deal that was made in the first instance. Instead, they're just going to be read in by force of law, if you will. And in the property analogy would let us think, like Christian suggested, maybe you could say, look, there's some sort of trespass or some sort of action you've taken that's reduced the value of my share of stock, but that is not the approach that we see in the case law. So judges are not justifying the private right of action by saying the holder of a security is entitled to, the reasonable value of what they purchased, free of destructive acts by third parties. No. Because if that were the case, then you'd probably have a right of action against anyone who took any action to reduce the value of your property. So both of these analogies, both of these sort of ways of thinking about secondary market transactions have limitations. And so let's move forward here. But you see in Carden that the court just basically says, look, there is a statutory regime, and it's a matter of tort law that what's the exact language? The disregard of the command of a statute is a wrongful act in a tort. Yes? Yep. Yeah, so there should be no common law, but you see the problem is if you go that direction, Magdalena, you don't have a statutory basis for a private right of action. And in fact, your presumption in admin law is that there is no such thing. You don't get to sue every administrative agency for, you know, under the APA you can sue. Under tort law you can sue. Yeah. Right, that's why we have torts, exactly. But you need a common, my point is you need a common law basis, because the moment you jump over to statutory land, you have real problems, right? Because the premise, I'm not an ad law person, but for those of you who are, the premise, right, is that you don't just get a private right of action for every bad thing an administrative agency has done, right? Or, okay, so you need, and this challenge with scoping the private right of action is actually going to quite bother the court, right? So we saw you read in the notes following Cardin that in the superintendent of insurance case, there's the well-known, oft-cited footnote with citation to Professor Loss that it is well established that there is a private right of action. That's 25 years later. But, you know, politics change, the court changes, and there is an evolution away from this philosophy that we will allow private plaintiffs to bring suits for violation of the 34 Act in particular, or other parts of the securities laws. And there's a little bit of a back and forth. There's this Transamerica case where in 1979, the court holds that there's no implied right of action for violation of the Investment Advisors Act, the anti-fraud provision 206 of the Investment Advisors Act. Unfortunately, we don't have time to cover the 40 Act, which is a really cool area, but will have to be for another class. On the other hand, we saw they started ping-ponging back and forth and says, no, in fact, there could be under the Commodities and Exchange Act a private right of action. In this Aaron v. SEC case, the Supreme Court, I'll just read this, held that scienter need not be shown to establish a violation of Clause 2 or 3 of 17A. You remember 17A of the 1933 Act? It kind of has this similarity to 10b-5, but as you read here in this Landry case, and this really hasn't changed, it turns out that there is not a private cause of action under 17A of the 33 Act. Even though 17A pretty much copies verbatim the language in 10b-5, well, there's some hesitation with allowing a private right of action there. Okay, so there's definitely a private right of action for violations of 10b and 10b-5, and that's going to be the basis for our conversation for the rest of the term. So the question is, who is entitled to bring suit under 10b or 10b-5? And as I was looking back over these readings this morning, I realized that it's a little bit confusing the way that this stuff is laid out. So I just want to try and organize it for you if you were, applying this to a question or just trying to understand it for yourself. Remember that we're going to start with the language always of the statute and of the rule. And I'm not going to go over, pull it up here. You have it in front of you, but we need to show some sort of fraud, misrepresentation or omission or scheme, artifice to defraud, in connection with the purchase or sale of a security. Now, it's this in connection with the purchase or sale of a security that is going to be the starting point for these additional requirements that have been read in part by the court and in part by the PSLRA, which we didn't talk about so much yet, but we will. But just before we get there, think about the problem of deciding who has purchased or sold a security in connection with fraud. And let's sort of take it one step at a time. And in blue chip stamps, we get the kind of first cut, if you will, at who is not okay eligible to bring suit under 10b-5 for fraud in connection with the purchase or sale of a security. So what happened in blue chip stamps? Who wants a check? Yes, what's your name?
Charlie. Yes.
Good. You needed one, Charlie. Very good. Yes. Yeah. See, the hand went right up. Good. Yeah.
Yes. So in this case, there was a prior civil antitrust action.
Yep.
And Blue Chip Stamps in that action was required to offer its common stock to certain retailers at a reduced price. And then basically the defendants are alleging that Blue Chip Stamps intentionally made the prospectus overly pessimistic to discourage the offerees from buying the stocks that were intended to be a bargain offer.
Yep. So who exactly are the plaintiffs here?
I think the plaintiffs here are the offerees.
The plaintiffs are the offerees. So let's read on 1161. Respondent's complaint alleged that the prospectus, you're absolutely right, was materially misleading in its overly pessimistic appraisal. It alleged that Blue Chip intentionally made the prospectus overly pessimistic in order to discourage respondents, so those are the plaintiffs, and other members of the allegedly large class whom it represents from accepting what was intended to be a bargain offer, so that the rejected shares might later be offered to the public at a higher price. The complaint alleged that class members, listen carefully or read carefully, because of and in reliance on the false and misleading prospectus, failed to purchase the offered units. All right, respondent therefore sought $21.4 million. So the point, Charlie, I want you to what I was looking for, like what you want to focus on here is that this is about failing to buy, right? We're on the same page, right? This is about failing to buy. Okay. So if you fail to buy, you suffer damages, in this case, the amount of $21.4 million, which represent the lost opportunity that you could have had if you had bought. So overly pessimistic prospectus, you're very sad and you don't buy. You read this terribly pessimistic, and then you see that had you bought, the price would have been higher down the road, and thus you lost the opportunity to make money. Okay, everyone sees this. All right, so Charlie, what did our Justice Rehnquist have to say about that claim?
So he does not think that the plaintiff has a standing here because otherwise it would just be to give too many plaintiffs standings in similar cases.
Exactly, that's right. So he makes reference to this case. What's the case he talks about 100 times?
Birnbaum?
Okay, Birnbaum. So, do you know what happened in Birnbaum? No? It wasn't in the readings. Did anyone look at Birnbaum? Just because you were curious? So much free time in April. Yes?
All I know about Birnbaum, this doesn't seem to work.
Yeah. Yes. Yeah, so Birnbaum was an offer to minority shareholders who claimed that they basically tried to bring a standard corporate law fiduciary duty claim under 10b-5. And the argument and the problem was that they didn't actually transact, and Birnbaum wasn't ratified by the Supreme Court until blue chip stamps. So in a way, it's really the blue chip stamps rule, which is that there needs to be a purchase or sale, not the absence of a purchase or sale. So Charlie, you said, well, the concern is that there might be too many plaintiffs. Do you find that convincing?
I mean, somewhat convincing, because I do think to hold otherwise might risk turning the securities laws into a form of insurance for investors. But on the other hand, I think in this particular case, the plaintiff does seem to have some legitimate reasons for, damages.
Good. All right, so let's think concretely about this. So remember yesterday, we said you had all these folks who could have, right, not, well, all right, so let's think back to Martoma, right? So Martoma's going out there and he's selling, and he's moving the price just a little bit. And basically, you have an entire group of folks who could have, like Martoma, sold at that price of $35 and made a lot of money doing so. And we said that there was actually a lot of trading happening in that window, in between the moment when Martoma realizes from Dr. Gilman that the test, that the Alzheimer drug is not going to work, and the moment when Dr. Gilman stands up there, there's a lot of trading happening, a lot of trading. And if you computed the value that was lost during that window, you reach a number like 1.2 billion if you compare it to the value, using the August date. You saw that in the Excel sheet. So the question is, if you think about these folks who did not trade as a result of something, and that's really going to be the question, because it's not exactly clear, and the Elkind case is really going to illustrate why this is not clear. But let's just roll with this somewhat slippery idea that I would have sold but for Martoma's selling. It's really actually not clear at all what that means, but let's just go with it, because it's how the courts some people like to think about this. So, Martoma's selling, and I guess you could say that there's all these people out there who could have sold but didn't. And the blue chip stamps rule says, too bad, so sad, you are not included. Instead, the only group who would get to bring a private civil claim is the group of folks who actually sold, purchased or sold, let's say for now, in that week when Martoma was trading. Now, why would that rule turn the defendant, whoever the defendant is, into an insurer? Because if you think about that group, potentially all of those investors, it would be a lot of liability. I agree with you there. But why does it turn them into an insurer? At the end of the day, aren't we kind of picking sort of randomly, if you will, almost, the winners here and the losers? Because if you traded unaware, in this example, of Martoma's fraud, but you traded during that time window, why is it that we're going to basically reward you for executing trades and not reward you for not executing trades, remember that just as many people sold as bought during that time. So among the group who executed trades, there were just as many winners as losers. And among the group who didn't execute trades, if you suppose that, if you just look at the existing stockholders, you can say all of those stockholders were losers, for sure. There might have been another hypothetical population that could have bought during that time, but at a minimum, we know that those who traded in both directions because the price did not move. We talked about that yesterday. And we know that those who are the existing shareholders of the firm definitely lost an opportunity to sell. Does everyone see this? So Charlie, why is it so bad to compensate? At the very minimum, I mean, you don't even need like hypothetical populations, right? You've got a group of existing Elon shareholders who lost a chance to sell their stock at $35. Let's stipulate that that had something to do with Martoma's trading. So focus on the definition of who is included. What's wrong with giving those people compensation for the amount that they lost? That is, that's what they could have sold at during that window.
I think one potential reason I can think of is that it might be more difficult evidentially to prove that you refrained from, but for the misrepresentation, you would have transacted than to show in the other case.
All right, so so let's tease out this but for. Admittedly, like I said, this is kind of convoluted, confusing, and tricky. Let's just make sure you see where my hesitation here is coming from. If you knew that Martoma was trading, what would you have done? You would have sold. Okay, so it is but for Martoma's silence that you didn't sell. That's the, okay. So but for Martoma's non-disclosure of his trades, you wouldn't have sold. Let's suppose that's true. It's a problematic assumption, but let's suppose that's true. Now, why is it hard to identify the group of people for whom, but for the lack of knowledge of Martoma's trading, they would not have sold? Because at the very minimum, you could say, look, it's at least some fraction of the existing shareholders. Does anyone see, sort of, is there an argument why? Yeah. 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 Well, I mean, I think you're all kind of saying what Rehnquist said. We can't really prove it. We have all these evidentiary. Yeah.
Could it be that if we've talked a lot in the class about how we want to have kind of liquid markets with lots of participation.
Okay.
And if you can kind of be compensated for kind of waiting and holding and then seeing if you didn't buy or you didn't sell, then you still kind of have a remedial right, then there's kind of less of an incentive to trade in the first place because you can kind of make up those gains or losses.
Nice. Yeah.
Whereas if you do trade and then you lose, then it makes sense to have that remedy.
What was your name? Ophir. Yeah, I knew that. Right. Good, Ophir. Very good. So Ophir makes this nice argument, which is to say, look, maybe there's this is about sort of injecting liquidity in the market and encouraging you to trade rather than, so this is like the insurance, right? So Charlie, you weren't wrong. I'm just trying to see if you can articulate this. So, well, here's a look, I'm just reinterpreting you. Okay? The insurance is that if you think something might be up, but you're not sure, you're a little skeptical about the Alzheimer results, or you have some doubts, and you think there's a chance that there's a martoma out there, and you wait. And as a result, you just think, well, I'm just going to wait and see if I can find an insider who might have traded, or the other ways I could do this. But then I'm going to wait, I'm going to wait, I'm going to wait. And then if it turns out there was a martoma, then I get the best of both worlds, right? If the news is good, I'm still in the stock, so I profit. If the news is bad, I get to sue Mr. Martoma, or the company, or someone. And my failure to sell is a basis for 10b-5 liability. That is, it includes me, I should say, in the class of potential plaintiffs in a Rule 10b-5 claim. And that's great, because that means that whether or not things go up, or whether or things go down, I get a payoff. And that is insurance. Yes? Yeah, you're procedural. You don't like procedural stuff. Yeah.
Let's say Martoma had sold
Yeah.
for totally separate reasons.
Okay.
And you knew he was out there and you knew he was selling. So you assumed that the drug was bad.
Yeah.
There was bad news. So then within that window, before the announcement was made, you find out the drug actually cured something else.
Okay.
It does really well on something else.
Yep.
So then that announcement comes out and you sold. What would stop you from then being like, oh, well, I would have kept it. I would have made all this money because it turned out to cure something else. And that's
Right, so you like the speculative nature of the claim. But I'm not sure, so I'll just, I think this was what some of the articles that Rehnquist found unconvincing, but what there's, I'm not sure it's so speculative. I mean, that might be speculative, but there's a simpler version of this, which is just any existing shareholder is entitled to bring suit for the decline in value. Period. We don't need chains of hypothetical action that you might have taken. Just literally, the class expands, consists of the actual buyers and sellers of the stock. Okay? I mean, the sellers are fine, right? They sold by random chance. They got lucky. They sold at the same time as Martoma, and they're in good shape. The buyers are unhappy. So that's definitely a group that would be bringing a fraud lawsuit. So we say we're just going to augment that by all existing shareholders who did not sell. Scott. Yeah. I saw your email about this. This is great. Yeah, so Scott sent me this cool email where he says, and maybe a lot of this is just federalism concern. Yeah, I think that's probably right. I think you're right. I think that there's I think you're right. I think that there's a judicial aversion to turning what is a well-established system of checks and balances between minority and majority shareholders. But remember that a lot of these, where that falls short, I'm not even sure it falls short economically. Let's stay in the land of lawyers for a minute. Remember that, a lot of 10b-5 is nothing to do with fiduciary duty violations between classes of shareholders or between management and right? That the entire misappropriation theory, including the Martomas of the world, have no fiduciary duties to the shareholders of companies like Elans and Wyeth's. Right? So even in law school world of just the law, at the end of the day, it's not it's hard to justify the scope of securities law via federalism concerns, and it's not clear that just saying, look, the existing shareholders at a minimum should have a cause of action against a Martoma type, right? So that would be beyond state corporate law for sure, because Martoma had no duties to those shareholders, and it wouldn't be hypothetical action that would form the basis of that. It would just be, look, all existing shareholders could have sold at 35, and that was the harm. Does anyone disagree with that? There should be an immediate, you should see, Lisa, what do you think?
I was just going to make a comment about the liquidity concern, actually. And also, well, if the law incentivizes people to just hold on to the stock and not sell, isn't that increasing liquidity rather than like decreasing?
Well, if you hold on and you don't sell, there's less. So I guess you might say these are informed transactions. So if I'm selling because I have a hunch.
Right.
Maybe, yeah.
I was just saying, like, I didn't quite get the, well, I understand the liquidity concern, but I felt like it kind of goes the opposite way. Well, I was going to say there's the price accuracy concern, because if people just hold on to it, then, like, the price doesn't adjust as fast as possible.
Right. So Lisa's put a nice spin on it, which is to say maybe, it's actually not a liquidity story because the kind of trading that would occur if you were a member of this class under the Birnbaum, who's precluded by the Birnbaum rule, the blue chips rule, that selling would be informationally motivated at some level, and thus would tend to actually increase bid-ask spreads. It's a kind of like, wouldn't you, nice, yeah, good. Okay, so wouldn't you rather keep the informed traders, have them hold on to their shares? It's the whole idea, because if they trade, then that increases the likelihood that the trading is informed. So maybe what this does is kind of cabin off the possibly informed and sort of keeps them out of the market because if they have a hunch they would sell. So then you're saying, look, the other concern though is price accuracy. So price accuracy is where I want to take you. But Paul has his hand up. Yeah. Right.
So if the notice occurred earlier and you didn't trade, you still would have lost all your money.
Right. That's what I want you to, exactly. That should be your immediate instinct is to say, wait a minute. Like, if you are uninformed and didn't sell, you're still out of luck come July 29th or whatever. Like, who are we talking about? Those who are going to sell the minute before Dr. Gilman gets up on the stage? Is that our victim here? So you want to, so you could push back against, does everyone see this? You can push back against me and say, well, you want to expand the class to include all existing shareholders, including those who would never trade. But those who would never trade would lose anyway, just 5 days later, right? Like they would lose when Dr. Gilman says, I mean, the assumption is that they're not trading. They're not trading. So they're not trading. They take whatever risk. So who cares that? Wow, shouldn't even give them a fraud claim at all. They're Sajul, yeah. Right. So Sajul says, look, we can't hold the disclosure date fixed kind of in the story, right? So it could be that we might be just, gratuitously bestowing cash if we expanded the class here on those folks who didn't sell. Gratuitously in the sense that, like, really, they would have suffered the loss either way. But the firm's disclosure behavior might change. Because in order to foreclose that additional liability, right, in order to reduce rationally, the firm might respond and accelerate its disclosure, concerned that there would be a large class out there. And so prophylactically, right, it might actually be great because then companies are talking more and talking sooner because it reduces their liability. Now this kind of, yes, Mariah. Right. So Mariah says, look, it's not, maybe the Satchel effect won't happen because this ex post litigation is kind of like insurance anyway, is what you're saying, right? It's sort of mispricing insurance. Now, yeah, it's predicated on some kind of securities fraud. It's predicated on some entry point, but if you get in the group, you get the difference between the price that you actually landed at and what you had prior to the moment of the fraud. So your losses get made whole. Now, if that's the case, then maybe disclosure in general isn't needed. Well, so we'd have to think. So if you remember whose incentives are involved here, right? So Satchel points out that the firm would have an incentive to disclose. Let's talk about that for a minute. And this is a point we'll come back to a lot in the next week or two. Because then of the circularity of securities fraud litigation. When the firm pays, which we'll see the firm pays a lot of the time, who is paying? What is the firm? The firm is just a legal entity, the value of whose shares is the stockholders, right? Like, the value of the firm's shares is actually equals the wealth of its shareholders. Like the value of the firm's equity is the wealth of its equity holders, part of their wealth. So by reducing the value of the firm, you reduce the value of you make the shareholders of the firm less wealthy. Of course, if you're paying those same shareholders, then literally nothing changes. But often you're not paying the same shareholders. We'll get to this. You'll read about this a little bit. But often you're paying other shareholders, and so you're just transferring from one shareholder to the other shareholder. The problem is that if these shareholders are changing in time, right? So I buy the shares from Mariah, and Mariah sues the firm, which is effectively suing me as the existing shareholder, because when the firm pays, my shares go down in value. Then, wait a minute, Mariah was there when the lack of disclosure decision was made. I wasn't in this story. So how do we get Satchel's incentive story? Right? So Satchel says, well, if firms are afraid of expanded securities law liability, then they'll disclose earlier. Yeah, except that if it's the same shareholders, nothing changes. And if the shareholders change, the ones who pay are not the ones who were there. Right? So there's a problem with thinking about securities fraud liability as an incentive mechanism because it doesn't quite work in time. All right. Yes? Yeah. Yes. Yeah. Yeah, so exactly. So, they say, good cases make bad law, right? So the failure to buy seems to be the least, as Dexter was saying, seems to be the least convincing because the failure to buy, you got is this hypothetical chain of action that you would have taken if I had known that Bitcoin would have been worth $20,000 in this one, then I would have bought. But okay, go figure, right? Maybe, who knows? You can never prove that. Now, failure to sell is a lot easier to prove because you actually have a shareholder class. Like, we know who the shareholders are. So yeah, the law gets made on a set of facts that are very nice for Rehnquist. Like and he doesn't like the judicial tree that's grown out of the acorn, and right. So he's not happy with the scope of private securities fraud. Yeah. Okay. Anything else? Yeah, Martin?
I really don't understand the distinction entirely that you just made between buying and selling. I mean, I get that, if it's just a straight failure to buy stock, theoretically, anybody could say, oh, well, I would have bought it. But isn't selling kind of identical to buying a short position? Or
Yeah.
like theoretically, kind of, you'd say if I would sell, I would also buy a million short, or I would short this a million times.
Yeah, except, you know, it's like we kind of know who the existing shareholders are. So there's a little bit, if, you know, for judges who are afraid that the whole world is going to claim that they could have bought a derivative on, you know, and it just never ends, we could cabin on a particular group. And the problem is, and we might think, and so it could be, Sachalo's point, it could be that that would induce greater disclosure ex ante. On the other hand, it's not entirely clear, as Mariah and I were discussing, whether there's an identity problem, who is going to be incentivized. But yeah, maybe with the right executive compensation schemes, maybe we can work around that. So it's not without hope. Okay. All right, we have 5 minutes left. Let me just say we'll talk a little bit more about List v. Fashion Park. This conversation led to the cases that you read, where basically, you know, there's this. Really, List is really the law, which is that there's going to have to be a requirement that not only that you purchased or sold, but that, as we read on page 303 of the reader, that the plaintiff would have been influenced to act differently than he did if the defendant had disclosed to him the undisclosed fact. There's a requirement for causation in fact, if you will. We're going to talk about this next week a little bit more, and we'll talk about the problem with proving it, which has led to the fraud on the market doctrine, the fraud on the market presumption of reliance or causation in fact, that is distinct from loss causation, which unfortunately we didn't get to today, but you can read, and I will put this in the email, read 15 U.S.C. 78U4, which was enacted in the PSLRA in the 90s, 95, which requires, in addition to this kind of causation, it requires loss causation, section B4 here. And the distinction between the sort of causation in fact, or the transaction causation that we'll discuss that arises out of List v. Fashion Park, and the fraud on the market presumption addresses the distinction between that kind of transaction and loss causation is an important one, and it gets to some of these conversations we've been having about who is injured. One last administrative note in the remaining 2 minutes. A couple of you have asked for some relief the last week of class because we're scheduled to be here Tuesday and Wednesday, and I guess your first exam is April 30th, which doesn't give you a lot of time. My current inclination, although I'd be happy to hear your thoughts and any feedback, either in an organized, where's Ben, organized fashion or individually, is to do a review session possibly on Tuesday, the 24th. I might go over the exam question I sent out from an insider trading perspective, because I said that could be useful preparation, and I think it is. So my inclination is to do that. You can send me your questions beforehand, and to not hold class on Wednesday. If you like that plan, let me know. If you don't like that plan, if you really want one more or two more lectures, let me know. I'll see you next week. I'll send out readings. The readings are clearly, you know what they are. I'll just remind you of what we're going to focus on next week, and I'll see you on Tuesday. Hey, Michael, what's up?
Sorry, is there any good one-book review book that you recommend?
Well, you know, there are the sort of E&Es you can look at, but the question I sent out is probably, if you feel good about answering a question like that, that's what you're going to see on the exam. Plus a few multiple choice questions. So,
Okay. Do you
yeah.
think there's any good homework that would test us kind of on multiple choice? Just to make sure we have.
You can look at some of the questions at the ends of the casebook chapters. I would look at those. Like particularly if it's a section that we talked a lot about. If it's a section that I skimmed very quickly, don't worry about it. But if it's a section that we talked about, like section 5, and there's a couple hypotheticals, no, I would study those.
Okay. Thank you.
Yes. And I didn't reply.
No, I didn't get. I know you're super busy this. I figured I'd just ask
It's
you after
just
class to
insane
set it
right
up
now.
with
All right,
you.
let me look at my calendar. How about tomorrow? Tomorrow work? Friday?
What time tomorrow are you free?
Let's see.
Some clinic stuff, but I might be able to. I'm free all day Monday and after class Tuesday.
Give me 1 second. I have a meeting. I have a meeting scheduled with someone else from 2:15 to 2:45. 2:45 here. Actually, Monday might be easier. I do have time on Monday. Let me look at Monday.
No, I understand. I'm like thinking through my
Yeah, Friday might be a little tight. All right. Monday afternoon.
I'm free all day Monday, so
Okay,
yeah.
how about, so we have a workshop at 4:15. How about before that? Is a half hour okay? 3:45?
Yeah, that'd be great. 3:45 Monday, and you're off. Okay. No, I really appreciate it. I just started outlining stuff, and
Yeah.
I had some questions and confusion,
Absolutely.
and
All
just
right,
like.
looking forward to it. Yeah.
And then I have one more question.
Yeah, what's up?
For today. Will you restate your example about the misappropriation of Google and Apple? I just didn't follow
Oh,
when
yeah.
it would and when it wouldn't be.
Well, so if the CEO receives confidential information from the board or from others in Apple and then personally trades on Google stock, that's clearly misappropriation.
Okay, that would, even though you're talking about the CEO of Apple trading, okay, still misappropriation.
On Google stock.
Yeah, I just didn't know since they weren't getting the information from Google versus.
No, that's O'Hagan, right? So O'Hagan gets the information from the acquirer.
Yeah.
Who trades in the target share.
Oh, true. Okay. So, now, if he didn't get any information, would that be okay? Like, if he just.
Well, yeah, then it wouldn't be. There'd be no.
Yeah.
Material non-public. No.
But then he probably wouldn't trade because then the whole point
Right.
would be okay. Perfect. Okay, 3:45.
3:45 on Monday.
Thank you so much.
Yeah.
I just need a signature.
Yes. Do you have a pen? Yeah. Absolutely. And the date is 4. Absolutely.
And here.
Good point on the liquidity. That was a nice one. Yeah. Well done. Yes. You too.
I can like follow you out if you're.
Yes. We have a lunch here. What's going on?
Okay, just really quick. I'm just like trying to.
Yes. Well, so think about common stock. Do you think it's a contract?
No, because I think of like what you guys said in class. I think Martin, especially Martin's point that like how would you prove okay a breach, a contract breach?
Yeah. What's your duty, right?
Like, what is your duty?